It's Wednesday, October 8th, 2014, and this is the Product Mentor Talk. Today we're joined by one of our mentors, Calvin Chu, Chief Operating Officer of Red Balloon. He's going to lead a talk today on intellectual property recommendations for startup product managers. And just let me briefly explain the format to everyone. Though, if you have questions that you want to submit, basically we have a Google Moderator channel that you can submit your questions to. Calvin will be speaking to a deck that he's prepared, and as the questions come in, I'll be jumping in and posing those questions over to Calvin and getting answers in as near real time as possible. And again, we'll be using Google Moderator, so if you're visiting us on the productmentor.com/live, right at the bottom of that page is our Google Moderator channel. Just post your questions right in there, and I'll get them right over to Calvin. And I am Jeremy Horn, a.k.a. the Product Guy, and I'll be moderating tonight. And we'll be joined by mentors and mentees, probably on and off throughout the talk. And so with that said, I just want to do some quick kind of go-around of introductions. Looks like I'll be very quick right now. I'm going to start with you, Christina.
So, hi, everyone. I'm Christina. I'm a project manager for an edtech company in Brooklyn, and I'm a mentee in the Product Mentor group because I'm interested in making the transition between project manager to product manager. So I'm really excited.
Awesome. And then we'll transition over to Calvin to introduce himself, and when you're done there, Calvin, you can just dive right into the presentation.
All right, Stu. Yeah, this is Calvin here, and very honored to be presenting again on the Product Guy talks. And I've had a long background as a product manager and in product management through a number of different startups, and today I'm not specifically a product manager, but I'm taking all that I've learned into everything I do for mostly startups. So let me throw the deck up. Hopefully there's no snafus, and we'll get started. Google Hangouts. Here we go. All right. Hopefully everyone can see that. So today I'm a Chief Operating Officer for Red Balloon Security, a new, hot, up-and-coming cybersecurity company that's doing antivirus for embedded devices, all connected and non-connected embedded devices in the world. So, and I'm also co-founder on a new connected toy company called Untitled Chapter. So I've got my hands full, basically. And here is just a brief slide on my background. I've been a serial entrepreneur for many years, and I've started a number of different companies, and while in those companies, I was product management, heading up product management a lot of times, or basically doing all the product management work. And I've sold my most recent previous company back in 2007, and then I joined Columbia Tech Ventures and worked to spin out probably around 4 to 6 new companies per year for about 6 years, and really got really sharp on intellectual property issues related to new products and new codes. So some of that knowledge I'll be passing down through this presentation. And since then, I joined Techstars, founded the RGA Accelerator, accelerator in New York City, which is an investment vehicle for funding new connected device companies, and it's gone incredibly well. And since then, I've decided to start up a couple of new things, which I talked about, Elemental Path and Red Balloon. So anybody has questions about those, so hit me up offline about those. All right, so we'll jump right into it. So the kind of the big thing that you hear a lot about with people who are pro-patent, anti-patent, its history goes down to basically squishy versus non-squishy technologies. So mostly I'm going to be focused on information technology, hardware, software, that sort of thing, versus the like medical device, compounds and molecules and things like that. In the world of health technologies, the kind of the big signature way that they do their patenting is when they go through and spend their billions of dollars to develop their products. Everything relies on perhaps a single molecule or the process for creating that single molecule, and then that single molecule makes its way into a pill or an injectable. So for those guys, when they set up their patenting strategy, they want to make the single strongest, most expensive, most powerful patent ever, right? So it's usually one or two patents that like $1 billion of product development revolves around, and basically the product lives or dies and survives on the market because of that. And everything about health products is related to how strong that patent is versus generics and people willing to try to knock it off and stuff like that. And then for everyone else, like myself and almost everyone I know that's not of that world doing information tech type stuff, it's the opposite, right? There's no such thing as a single patent that will protect your stuff. And everything that we do when it comes to building product, you're going to have software that runs on someone else's hardware. It's going to be an app that runs on an iPhone that's protected by Apple, and everything is layer upon layer, thousands, tens of thousands, hundreds of thousands of other people's patents that you're going to be stepping on. And in the world of tech products that are non-squishy, the big focus is always on what's the layered approach to this? How do we make patents weak so that it doesn't cost a lot of money, so that they're affordable, and then they can be connected together to create kind of a composite strategy to protect the product. And so what that ends up doing is that the bigger software and hardware companies, they lobby with Congress to weaken and reduce costs of patents, because usually a large company like Intel or whatever, it's probably 100,000 patents just to produce a microchip. So if you're a product manager on like the Core 2 Duo or whatever, you don't want someone to come along with a single patent and nuke your product, right? So and at the same time, you don't want to have the entire product relying on a single patent either, because it's kind of far-fetched that you could have a single patent on a hardware or software product. It just doesn't make any sense. So because of that, there's kind of a divide. There's healthcare product people, and there are non-healthcare product people that are that they have totally different strategies. And so you hear a lot about on the extreme end, people who are just entirely anti-patent, anti-software patent, and those people are lobbying Congress, and it's just and they're really up against the healthcare people. So that's kind of the cause of a lot of this tension that goes on, and the cause of a lot of confusion too on what can or should be someone's particular strategy for protecting product. And I think that in a nutshell, for the kind of companies that I'm used to working with, and probably your type of company, it's going to be a multi-layered approach. And so the next thing is court guidance. In the last 12 to 18 months, there's been two pretty important cases that came up in the Supreme Court that directly affect software and tech company utility patent filings. And the way the court system and patent system works is basically whenever a high enough court says whatever the new standard for patenting is, it basically propagates its way down to the patent office, and changes the way patents are applied for, to what kinds of patents could be issued for. And it's really interesting times because kind of the nature of intellectual property's changed pretty significantly. There's this thing called the America Invents Act, which basically realigns the way the patent system works. So previously, whoever invents something first or comes up with a function or a feature first and can prove it, that has power in the when filing for patents. But the changes in recent times, makes it so that people who file first gets precedence. So what it means for product people is if you get your timing right and you file, then even if someone else truly invented it before you did it, you actually take priority, and you can basically get the credit and the power that a patent affords you. And then in a recent 12 to 18 months, these two cases, Bilski and Alice versus CLS, has come up that kind of radically changes things a little bit. So the first thing with Bilski is that basically there's a company that came up with a kind of a function or what's called a business method. It's basically a sequence of steps for solving some kind of problem. So probably the most famous kind of business method patent is like the Amazon one-click type patent. So another company came up with a business method patent, and what the court said, they invalidated their patent and said that anybody doing software-related patents has to now ignore the fact that in the past you had to show that your thing had to produce something useful, concrete, or tangible. And they said that's really no longer the case. Instead, your patent has to be connected with some kind of machine, right? So before, if somebody wanted to make a function that decides whether one stock is better than another stock, right? They would look at, let's look at something trivial like, oh, this stock has a higher stock price, so you should pick that one, right? And you try to patent that, they're going to invalidate that. But if now you say it's in an app, it's connected to a specific device like a phone, then they'd be more likely to allow it through. But it also means that if your product is also a web app that runs on a computer and it's not really connected to that one machine, then it's going to weaken what you're trying to get at. So that's the first one. Is in short, previously the courts looked to see if your patent is doing something useful or producing some kind of concrete, tangible result. The patent office no longer cares. They're wouldn't say so far, but the guidance to the patent office is it doesn't matter. It has to be something related to a specific piece of hardware. Then the second big thing just happened a few months ago, and it's causing, I guess, a lot of people to go crazy over this. And what they said in what the Supreme Court said is in that particular case is when people are filing for patents that are all software, and then what they said is software is basically like an algorithm, and algorithms are basically math, and math is basically a law of nature, and since it's against the law to patent a law of nature, therefore, like people trying to file for stuff that looks like math and algorithms will probably not get the patent. And they've been striking down patents left and right. A lot of people who have patents in the pipeline at the USPTO are getting rejections and stuff like that. And there's this quote I found online, and they said, let's be clear, if all these claims are not patent eligible, this case is the death of hundreds of thousands of patents, including all business method, financial system, and software patents. There has never been a case which could do more damage to the patent system than this one, and it may or may not be true, but what it basically means is if you're going for patent protection on a very specific feature of the product, then not only do you have to connect it with the machine, what they're now looking for is that the particular feature of the product you're trying to protect has to somehow improve the machine itself. So if your feature makes it so that the iPhone connects to a Wi-Fi access point 50% faster, then that'll probably fly, right? If you filed a thing which says I want to protect the following sequence of steps and it looks just like math, then it would probably be a waste of thousands, if not tens of thousands of dollars. So a lot of lawyers haven't even caught up with this yet. So so basically, that's going to be kind of the new world view as of probably the last 30 to 60 days. So it's pretty apropos. All right, and then not to put too much focus on just utility patents, which is where a lot of the really advancements are happening for software. There's actually lots of different legs and dimensions to IP strategy, and here are some of them: trade secret, trademarks, design patents, copyrights, utility patents, and then open sourcing stuff. So a lot of product managers, they really don't get into this area. The way product docs, especially in early stage startups or really with new products, especially, if you file for stuff early, and then the way things happen with products is stuff gets cut, things change, engineering comes back and makes major changes. The marketing people get back, things change. So if you file too early, then you end up with a patent that doesn't even protect the product. So a lot of product managers, they avoid this out of two reasons. One is because of the constant change in early stage of speccing out a product, and second, a lot of product managers don't really have an IP background, so they end up throwing stuff over the wall to an IP attorney. And a lot of product development budgets don't actually budget for an IP attorney, unless it's like a really huge company, like an IBM or whatever. Then what typically ends up happening is there is no protection. So a big piece of this talk is going to be kind of talking about how to budget this stuff in, and hopefully this is going to be helpful, and I have a few recommendations on that as well. So for everyone who aren't that familiar with some of these legs, I'll just run down through them really quick. So trademarks, they are symbols. They can be basically any word, name, a design, a device, a sensory agent like a smell or a color, right? So it could be a shape, it could be a sound. Basically, when people in the product world talk about brand, think trademarks. And then trade secret, it's anything that you're not really going to tell people, right? Like Kentucky Fried Chicken's secret recipe, or whatever code Google is hiding, in those secret containers that they have on both, whatever, right? It's stuff that you just don't want to tell people, that you would have an NDA, that if people knew, then it could wreck your product or make it too easy for other people to steal your stuff. And then there are copyrights, which a lot of people are pretty familiar with, and that protects creative expression, aesthetics, code, but it also protects physical things as well. Design patents is kind of the up-and-coming thing that, as of the last few years. It protects aesthetics, ornamental features, basically look and feel, and as of late, it's now covering software-generated displays, icons. So that's an area that a lot of IP attorneys, like even people who are professional IP attorneys, they're used to, doing physical appearance, like here's a design patent for a broomstick or whatever, right? But for us in the product world, we're building out a design doc that goes, here's what basically these screens look like, or here's a whole series of icons that compose my product. Actually, that falls under design patents as well, and a lot of people don't realize that. So, this is the realm of the traditional, very high dollar cost type things that protect functional features of products, and open source is the I think I don't have to go into that too much. It's really like putting your stuff out there, so that typically when you're doing product design in the open source area, you're kind of setting out a product and its source code out with a very restrictive license to gain market share, but also to function as a copyleft type thing to cause competitors to adopt it, so that they have to reveal their source code and basically allow you to gain benefit from others on the market doing similar things. So that has its place as well. I'm not really going to cover open source too much. That's like an entire talk unto itself. So my focus is going to be on just kind of traditional lengths, IP.
Calvin, I'm going to jump in right there for a sec.
Sure.
Christina's got a question for you.
Right. Hi, Calvin. I think you sort of touched on my question. I was wondering how developed an idea or product had to be in order to receive a patent. And it sounds like there's a lot of change going on in the law right now that's kind of dictating. I mean, can I just prototype something? Can it be at the prototype level?
That's right. So for the patent office, all they care about is whether you can a person who is knowledgeable in the art. That means another product manager that does what you do. That if they looked at this patent filing, they can replicate this product, right? So, for example, if you sketch out like an MRD for a time machine, you have no idea how to build it, right? And you put some made up things in there, and then you give it to Jeremy, right? He's gonna go, this is nuts, right? There's no way to build this thing, and the patent office will recognize that, they'll reject it. But if you lay out a series of screens and you go, here's the functional features, here's the workflow, here's what all the buttons do, literally that's enough to proceed, right? With
So it doesn't have to actually work.
No, absolutely not. So all you have to do is prove that you could build this, and that another product person could look at it and go, yeah, all I have to do is hire or bring on board an engineering team, some web developers, a full stack developer. They'll look at it, and I can literally make this thing happen in this amount of time. It's not a question, right? So
it's more like
that's all you need.
a plan. Like for instance, I guess you're saying the one-click purchase, Amazon one-click purchase button, which might no longer be eligible for patent protection. Is that what you were saying? Because it looks like it's algorithm-based, but
yeah, I don't think that would fly today. So because of the new change in the law, it's creating a new weapon to protect against patent trolls, because a lot of what patent trolls have are business method patents that would be invalid today, and then companies who get attacked by them can now go and cite Alice versus CLS, like, yeah, go ahead and try me, right? So I don't think that what Amazon did, would fly today, and I don't think they rely on it that much, for their business anyway. So they filed for it because they could at the time, but things always change.
So do you think it's a good change in the law? Like it's good for products and for startups?
I don't know yet. I have no idea if it's good or bad, but it creates like a very, at least before you toss stuff over the fence to an attorney, right? If you are looking at a utility patent and you go, oh yeah, I just want to protect the idea that I could drag and drop a picture of a of an item onto the shopping cart icon, and then it's in my shopping cart, right? And you explain to the attorney, most people just click the add to cart button, but me, I'm gonna have my site have a drag onto the shopping cart feature. I don't know if anyone's done that, but then but before you do that, if you consider that the patent office they want to know how's that connected to the specific machine. Is it like a touchscreen thing on an iPhone? Is it somehow improving the capability of the hardware? Right. So you go, oh well, not really. Right. Then you probably shouldn't waste your time because it's just going to go to the patent office. You're going to rack up fees, and then you're not going to get anything for it.
Mm-hmm. Okay.
So, cool?
Cool. Thanks.
All right. So then the other big question that you have to ask is detectability. So I think at some point in time, you're gonna get some kind of architectural layer diagram, right? Which is always a good place to start. You have your requirements document. It goes to engineering, comes back, and they go, here's how we're gonna build what you expect out, and then they're gonna go, we have a lot of really clever ways to implement some of these cool things you're asking for, and then the first question you have is, well, are any of these things new that no one's ever done before that could have protective value and stuff like that? But then before you do that, you have to ask yourself detectability. So if you reverse the situation and you're a evil competitor trying to knock off your product, the thing is let's say they did steal it, right? So what happens is if you implemented some awesome feature of your product on your website, and then they did the same exact thing, right? You look at it, can you, without a doubt, say that they stole it? Like they definitely copied this exact thing, this exact concept. Can you detect that? So a lot of times, a lot of the really novel stuff is happening like deep inside the middleware, deep inside the database or whatever. Right? So like in places hosted on the Amazon cloud, right? The only way you can prove that they're doing what you did is if you were logged into their instance on Amazon cloud and then you looked at their source code, then that's probably not a good patent to have because if they did it different than how you said in the patent, and then you go to court and it turns out you were wrong, then you're kind of in hot water, right? On the other hand, if you have some kind of thing which all you have to do is you look at it, and I'll show some examples. You look at it, an engineer looks at it, and there's like no doubt that they're doing exactly what it is that you're doing, then that's an awesome kind of intellectual property protection to consider, like early on. All right. So again, basically, who are the likely perpetrators that would try to knock off your stuff? And if you're doing like a really new product that is totally new, there's nothing else like it, maybe there's nobody, maybe there's somebody, but then you go and if they did do it, could you figure it out without a lot of evidence? Then if the answer is yes, then go for the patent or whatever. Right? But if it is no, then it's probably a waste of money. So would be don't bother. And that's really trade secret territory. So if you got some kind of cool function and capability that somehow makes things 10 times faster or whatever, then hide that fact. Don't file a patent. It's a secret because it would be impossible for others to know how, for example, how does Google do things so fast or whatever, right? They're not going to file a patent to explain that, right? They like the last,
Hello?
Yeah, I don't hear anything.
Uh-oh.
Calvin?
I think Calvin's been swallowed up by that thing we call the internet. Wait, I see something. No. Oh, it's when I look away he appears. That's neat. Let's just try to give him a moment to come back. And so let's just see where we are. Just give me 1 second. Let me reach out to him. See if he notices yet. 1 second. So how's the menteeing been going?
It's been good. It's been good. It's been a little hectic the last month or so. We've both kind of missed each other quite a bit. But Matt has been really great to bounce ideas off of. He's really very experienced and very, very open and willing to share his experience and knowledge. So it's been great. I've learned a lot.
Cool. Very cool. And so now I guess you're working on your article that you're going to be...
yeah, I need to. I need to work on my article.
Tell me so we can share with everyone all the things that you learned in the program the past 6 months.
Yeah.
Looking forward to that. Is that Calvin who came back? Oh no, I got a smiling face on my screen. That's nice. Oh, Google. Is it Google or the internet? That's the question. Let's see here. Just 1 quick second.
Mm-hmm.
No, that was not Calvin. Let's see. Oh.
Could be like a logo on something. And
hey, Calvin. Hey, Calvin.
Hi.
Hi. Welcome back.
Hey there.
I don't know. Did you realize that you disappeared for a couple of minutes?
Really? Shoot. Okay, where'd I cut out? Last thing that you heard.
What's the last thing you remember hearing, Christina? Christina's
muted.
muted.
Over detectability, and I think it was a slide after that.
Okay, so
And your screen share is not up anymore. We just see your face now. Which we love. We love the face.
All right, darn that internet. So
yeah, that's what I was blaming. It was internet or Google, or we could just, what's the difference?
let me pull that back up again.
No problem.
Here we go again. Okay, so on detectability basically comes down to whether other people, if they stole your feature, whether you can determine without without any deep investigation that they indeed stole it, that this has value. So basically, a lot of the newer, really unique stuff that's occurring is on the back end in the cloud. So if you really can't get into their cloud to prove that they stole it, then you're going to have a hard time finding value with any kind of IP protection for things. So I wouldn't bother on those things. You guys still with me? All right. So the next thing is trademarks. So these are all things related to branding, word marks, physical shapes, digital images formed by software. And that's the key, right? So everyone's used to trademarking a word or a logo, but that's not all there is to trademarks. And the thing that gives this thing a leg up is the law saying that you can trademark digital images formed by software. So you can trademark UI elements, icons, things that software is generating. So in this case, these icons are ones that Apple trademarked. you'll notice that these don't appear in any kind of phone. And anybody who replicates these exact icons, or even similar in appearance, then they're liable to be sued or stopped by Apple. So everybody who has to do it would have to do it a different way. So I think that if you get the right kind of digital trademark on things, then you're forcing people to do things in a more inferior way, and that gives you some advantage versus others. So and it's so it's besides brand, it's also about protecting kind of the look of what the software is doing. And then design patents is another thing which traditionally people think of it as ornamental appearance protection and stuff like that. So this talks about shape and the specific layout of the non-functional items on the product. So it could be kind of look and feel of different shapes on there, but you can't really talk about functional features. And you can talk about the kind of designs of different sub portions of the product and logo, where a logo is located and stuff like that. But this turns out to actually be very powerful, and Apple has pioneered how this is used. And I'll go into more examples of this in the following slide. So I think the other interesting thing about doing design patents is typically when you file for a utility patent on features of your product, as soon as you do that, after a certain amount of time, it gets published, even before the patent's issued, so everyone in the world can scrutinize it. But design patents, they don't get published, and they're incredibly inexpensive to do as well. So it's not as cheap as trademark, but it's pretty affordable as well. And then because of that, the combination of these two are pretty effective. And I think with design patents, it gives you this very specific feature, right? The design patents gives you the ability to stop others from making, selling, or using something that you described in your patent. And with trademarks, their power that is given to you is if someone else replicates what's in that trademark, so that others on the market might get confused as to the source of this thing. So if someone sees a phone that has those specific icons on there, they're going to kind of think about Apple, and then Apple is within rights to invoke their power to stop that product. So the combination of these are pretty decent, and even the same features and parts of the product that could fall in overlap, and that's what makes these two pretty powerful. And then rolling in copyright. Everyone with me so far? Checking. So people are more used to copyright in these, and copyright is really great because you don't really need to do much to create the protection. So as soon as you start designing a product or speccing it out, it begins to fall under copyright. And then when you're doing it under the umbrella of a company, then you have this protection for over 100 years. The only thing with copyright is if you file for an explicit copyright, then it gives you the additional power that if you sue somebody, then you get to ask for 3x damages, which is pretty cool. Without filing for an explicit formal copyright, then you only have the right to stop them, but there's not additional damage protection. So, but there are kind of differences between these three. The thing they have in common is it's really inexpensive to get a copyright. I think it's like $39, or design patents are really cheap. If you're a startup, it's super cheap because you can file as a micro entity and get like an 80% discount. So you can file for literally just a few $100, get design patents. Trademark, very cheap as well. So So you can actually get these three legs of IP protection for, for definitely under 1,000, probably just a few $100 if you're really careful, um, but not for the tens or hundreds of thousands that it could cost if you went and picked up a whole bunch of utility patents. So for the product management side, the fact that they're cheap and the combination together is very effective, it's really kind of a good thing to have in your toolkit. So what are the differences? So the protection comes into effect at different times. So with copyright, as soon as you create a spec document and describe it, and as each piece of the product gets built, it immediately becomes effective. Design patents, it takes typically a year or two for it to become effective and usable. And trademark, when you do product launch. So as you can see, copyright's good for in development and after. Trademark is good for when the product launches, and then design patents are really good for when the product starts picking up steam on the market. So then the combo kind of each other in very good ways, and then by comparison, to be sure, copyright alone won't protect you if someone, like for example, if you went to Mint and said, "Oh, that's Mint.com. I can do that overnight with my software development crew in India." I just tell them to go make what Mint has, and if by law, if they've never seen the source code and they produce something that does what Mint does.com, then and it doesn't look like Mint, then it's you can't use copyright to stop them, right? If you can prove that they've line for line or copied some of the site, then that's when it comes into effect. Trademark, it's basically if someone looked at it and people get confused as to some part of it or all of it, appearing to be just like Mint. Like if it's someone went and launched with maybe not Mint.com but like Mont.com, and it's like a green website that does finance, it's falls under trademark. And then design patents, what it would protect against is if somebody even independently did that design, never saw it before, and it looked quite a lot like Mint, then design patents could be a kind of a killer weapon against that. So what you have to prove to use it is along the bottom. If with copyright, you have to prove that someone saw the source code and copied it, and then it looks substantially similar. So like if you have like somebody on your team that left and then start up another company to do the same thing, then you just prove that they had access, and then that's where copyright falls in. Design patent is if it looks similar to it, then it is cool to invoke that weapon, right? And then trademark design, basically, if you can show that someone kind of thinks it looks like your product, then that's enough. All right, and here's a few examples of some stuff that I've worked with and what they've done. Right, Keen Home is a new up-and-coming company here in New York, and they produce a product that's a connected wireless vent, and it adds basically zoning climate control capability to any house, and up in February 2015, and what they found was that the concept of a motorized air vent has been done before. It wasn't patentable, which as soon as someone's done it before, then it's not something you can protect because someone else either has done it or it's not really available to be patented. But what they've done is they went in and started filing patents on kind of power management type stuff. So when someone puts a vent in their house or 10 vents under connected control, there's no electric plug there, so it's going to be battery powered, and no one wants to change their batteries every other week, right? It would be a terrible product. So they worked out a way so that these vents don't need to have their batteries changed for a very long time, maybe years, right? And nobody else has done that, so they've started filing for those features, and they've been layering on protection in many different ways. Another one of the companies that I've worked with is a company called Owlet Baby Care, and they make this great product, which is basically the best baby monitor on the planet. It's most baby monitors, they're glorified microphones or video cameras, and they expect the parent to be kind of listening to the baby at all times. But if the baby's asleep, then what are you really listening for? And if the baby's screaming, then pretty much you can hear the baby. So what their product is predicated on is if it's monitoring the baby's breathing, the baby's oxygen levels, the baby's movement and position, and then relaying that to mom and dad's smartphone, so that if something actually starts going wrong, baby starts to lose oxygen or stop breathing or flip over in a funny way, it'll then do the alert. But at all of the times, it doesn't matter, right? So they've been innovating, and they've been filing along features, along look and feel, trademark, all of that stuff. So they're doing multi-layer protection, which goes back to the beginning of this. Is really think about multi-layer protection all the time. And you all with me so far? Cool. So this was a company that I founded, which produced a handheld computer, which I was selling into defense markets, into aerospace, into agriculture, and ultimately into tourism and rental tour guide type products. And I'll give some examples of what I did here, and also kind of lessons learned from this. What I decided to do, because it was a new company, we raised money, but it wasn't a huge amount of money. So what I did was I did design patent only, right? I didn't really go into trademarks and others related to the design. So I went down with one leg, and the patent that I have is on this, right? And this is my first time doing it, and it was pretty good for what it was. And this is pre-Apple versus Samsung, so basically I figured I'll just protect against a knockoff this way. And then, of course, probably about I would say 9 months into this, working with our manufacturer in Asia, they went and released a product of their own, which looked like this, and I was pretty ticked off. Unfortunately, design patents take about a year or two to kick into effect, so I literally had no way to really stop them. And then they launched a market, and then a few months after that, the Koreans kicked in with a product that looked like this. So I was pretty ticked off. And then a month after that, the patent issues, right? So this is the actual patent. It came out, right? And so I think if you look at it, it's really similar. But what then happened was shortly after that, the company ended up being acquired. But what didn't go well with this patent is I didn't I went and was too specific on this patent. So I'll go to you some examples of how to do it right based on what Apple did. So let's look at Apple versus Samsung. It's a very similar situation. They have the iPhone. I think that's the iPhone 30 maybe. And then Samsung launched their Galaxy product, and on the right is their actual an actual patent and claim. So note the dotted lines. That's something I didn't know about at the time, and that's probably the most important takeaway from doing design patents is things that are dotted are not part of the patent. So what it's saying here is in terms of the look and feel and UX of their product, the thing that matters is the rounded corners, the rectangle in the middle, the little oval on the top. That's it, right? So the fact that there's a circular button, see how it's dotted? Apple is saying it doesn't matter what that is. It doesn't matter what the outside rim of the device looks like or whatever. All they care about is big rectangle with rounded corners, little rectangle with sharp corners, and an oval at the top. So that's the basis, one of the bases for the case against Apple versus Samsung, which resulted in like $1 billion judgment against Samsung. So this is a design patent which probably cost like a few $100 to put together, and then it ended up being $1 billion judgment against Samsung. Because look at it, right? When they went to court, they didn't have to prove that Samsung ever looked at an Apple device ever, that the engineers ever looked at or used an Apple device. All they have to do is go before a jury and go, so does it have rounded corners? And then on the the inside piece, is it like a sharp cornered rectangle? And is there an oval at the top? Oh yeah, then guilty, right? It's as simple as that, right? So that's the power that design patents have. And the two actual patents that Apple filed are here, in these cases, even in the claims of the device, you look at where every place that they have the dotted lines. They're literally saying that nothing about the look and feel of the product matters except for those solid lines, and that's what makes this patent really powerful. Is it anyone who's doing this, the fact is you're going to put a screen on something. No one makes a screen with rounded corners, right? Except very lately with the smartwatches with the round screens. But at that point in time, every screen was rectangle. So then after that, they said we're going to protect the rounded edge and the little oval at the top. And the crazy thing is Samsung could have put a square speaker at the top, and they would have gotten away with it, right? But they didn't, right? So they decided to put an oval at the top too, and that's $1 billion mistake for them. Good. So, just look at it, right? That's why. So people are going to be knocking off products. So here's like one of the companies that have equity in, that they're producing jewelry that blinks and vibrates based on social media content. They've got what I call a doppelganger, right? And Owlet, who I talked about, they've had multiple people doing stuff. I mean, look at some of the products on the market. It's remarkably similar. So in this case, this is like a trademark kind of power that could be invoked to stop these doppelgangers or knockoffs. Then this year I found someone that's remarkably similar to me. So this is somebody with my exact name who is also developing products in the tech world, hardware, just like me as well. And it's just crazy. We ended up running into each other on Twitter, and I ended up inviting him over when he flew to New York, and I met this guy. So things are going to be knocked off. Products will be knocked off. People will be knocked off. It's going to happen.
Did you sue for triple damages?
I allowed it. I'm like, yeah, as long as you're doing something cool.
Come to agreement who uses the middle initial?
I don't think either of us have a middle initial. Is that correct? No.
See, I think you got a cake.
Yeah. So all right. So that's the whole thing. Any questions?
No, I think we're pretty good right now. Christina, anything from you?
I've never encountered this at the my workings with product managers, and so do these type of decisions take place kind of the executive level, or are you saying that, maybe as kind of a junior or mid-level product manager, I need to be thinking about,
No, it
time
doesn't.
for design patents?
Right. The specific combo I talked about, it's specifically designed so you don't have to kind of require like some high-level budgeting decision to invoke. So what it does is this. You're going to do market studies, competitive analysis, analysis of other products and so on. So you're going to know, right, what's unique about your product. I would say you would have to know what's unique.
Right.
Right. So then, the first person who's going to know is going to be you, and then you go have a section that says we, recommend to protect, because as soon as you launch with this feature, right, like for example, Gmail launching with built-in anti-spam capability, right? Believe it or not, then right after that, Yahoo Mail offers it, Hotmail. Right. So I think basically what you do is you go, I'm certain that when this launches, others will follow like right away, and they're going to grab this feature too. So before launch, we need to file for the following things, right? We want to get a trademark on my buttons, my icons, whatever, right? Like the layout of the UI, right? And because when people see what Mint looks like or whatever, they're going to do a financial thing that looks just like that too. Or, soon after, Gmail came out, others started copying that look too. Right? It's kind of like that. So then you roll in design patents, you roll in copyright protection, where you need it. And I think with copyright, a lot of people think code and stuff like that, but really most people don't really copyright code. And plus, as a product manager, you don't get to see code a lot of times. So, so what you're copywriting is more look and feel, kind of creative expression, because the way you spec'd out something like, oh, it's going to have 3 tabs along the top, and it's going to have a split here, and have like drop downs here and there. That's your creative decision why you wanted those to be that way, because it's what makes it superior. And maybe someone else has to put 100 tabs to do the same thing, then that's a big deal, because now you can go, my creative expression is better than your creative expression. It's, you don't have to wait till it percolates down to the code level, and most people don't reveal their code to to the government, so it's not going to be it's not all that great.
How long do you generally have to budget for obtaining the patent / copyright / trademark protection? Because as your first example, I think the design patent kicked in after your competitors had kind of knocked you off.
Yeah. So the design patents, they basically give you power going back into time. So the day I filed for that patent,
so they are retroactive. They can go back and
So if it gets granted to you, then it goes all the way back in time to the day you filed for it for patents, any kind of patents, design, utility, whatever. Right? And then I can then call those people and go, guys, like cut that out, stop, right? Or pay me money, whatever. Right? So, but you can't do that until you get the patent. So that's the thing is the design patents take like a year, 2 years, right, before you get power. And then so if you file it today, you get it 2 years from now. In between that time, a bunch of people knocked off your stuff. Then you have to wait till the government says, okay, you can go ahead and invoke your power. You got to wait, right? With trademarks and copyright, it's instant, right? Upon launch to market or upon creation of the thing. So
it's sort of staggered protection. So you kind of get, you're minimally protected once you launch, and then I guess the hardcore protection kicks in.
That's right.
So it's a risk. People will knock you off in the interim period, but
yeah, and I think that by layering those things in, especially this combo, it doesn't require a lot of money, right? I think that if it's a small company, you get that 80% discount. It ends up being just like a few $100 to file for a design patent. for a utility patent, even with that discount, it brings it down too, but you're going to have to budget, closer to 10,000 for a utility patent, whereas a design patent is closer to 1,000. Copyright's like $39, that sort of thing. So overall, if you, as a product manager, you just go, look, it's just like you go, I've got to license this thing or use, whatever feature that you have to get from somebody else. Just also go, we need to have like a couple of $1,000 to protect these things, and here's why. Because as soon as someone finds out about one click to buy, they're going to go try to knock that off, which people did for Amazon, and then Amazon went, and told everyone to stop because it's within the rights.
Cool.
Awesome.
Thank you.
So I'll just end with some just final comments here. So as always, the presentation will be posted to our SlideShare channel. And again, thank you to our speaker, Calvin Chu, COO of Red Balloon, for today's discussion on intellectual property recommendations for startup product managers. And a big thank you from me, Jeremy Horn, the product guy, to everyone else who joined us today, and the product mentor. And also don't forget, if you're interested in being a product mentor, just like Calvin, you too can sign up at theproductmentor.com. We're always looking for more good mentors, and you can be from really anywhere in the world. Our program is worldwide. And also, if you're looking to fill a new product job with a great product person, we have our very own free for everyone job board that is available to the members of the product group and really the product community at large. And you can access that at theproductjobs.com. And once again, everyone, thank you again for joining us, and we'll be back again soon. Bye.
All right, bye.